I mean, I'm not even worthy to be breaking. What your destiny is going to be. Once you face this information, once you've consciously admitted it to yourself, it will take over your life. It should take over your life. Well, I mean, what else? What else could it do? We've got to get past the artificial stigma that the controlled corporate media has been putting out for decades ahead of their unveiling of planetary dictatorship. They all talk about how we need a police state to carry this out.
Canada and the United States are going to work in lockstep to display the seriousness of our commitment at both home and abroad.
Win, lose, or draw, you need to choose a side.
The increase in suicide deaths in Alberta and Canada have grown exponentially and actually supersede the COVID-19 death count.
An Alberta town is reeling tonight after 3 people died in the same home, all from a suspected overdose.
Police were called there around 7:45 last night, but it was too late.
The government has taken away our goals, dreams, happiness, and ability to prosper over a virus with a 99.9% survival rate.
German Lutheran pastor Niemöller said he condemned the cowardice of the clergy for their silence during the Nazi time. He said first they came for the socialists, and I did not speak up because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and that I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak for me.
When are we as Canadians going to say enough?
I would like to quickly give you a 2021 rendition of Niemöller's poem. First they came for the restaurant owners, and I did not speak out because I was not a restaurant owner. Then they came for the dissenting politicians, and I did not speak out because I was not a politician. Then they came for the pastors, and I did not speak out because I was not a pastor. Then they came for me, and there was no one left to speak for me.
We stand here and seek hope and answers that our leaders will give us direction and truth. But unfortunately, it has fallen on deaf ears. We have stood on these legislative grounds in every province, in every city, across this country, and thousands of citizens have stood and voiced their concerns. At the end of the day, are we not all just looking for answers and solutions?
I want to ask you this afternoon, what would it take for us to wake up, folks? What will it take? They told us they will never put pastors in prison. They told us that was a conspiracy theory. I want to tell you something this afternoon. I've got no conspiracy theories left because everything has materialized.
If we don't step up now, the government will continue to rack up fraudulent debt, spending trillions of dollars that we will have to pay back with our rights and freedoms and right to ownership.
Thank God that God has not given us the spirit of fear, but the spirit of power. Scripture also says it is better to have a living dog than a dead lion. I thank God that we don't have to be afraid.
The only way we are going to beat this is by mass non-compliance. The government has no intention of allowing us to return to any resemblance of normalcy, as evident by constant, continual, unjustified, and completely non-scientific lockdowns, repeated violations of our rights and freedoms, and pre-planning on a third wave with new variants to extend their control mechanism. Only by aggressively taking our lives back, open up your businesses in mass, and living our lives the way we choose.
The world needs to hear Pastor Coates' last message he preached last Sunday. The whole world needs to hear it, especially the clergy. Now, I'll close with this. There's 3 reasons why we should practice civil disobedience. 3 reasons. When the government commands what God forbids, we should not obey. When the government forbids what God commands, we should not obey. And finally, when the government commands what isn't theirs to command.
What is going on here? Can you guys hear me? Let me know in the chat. I don't know what's going on with my camera right now. Hang on. There we are. Hey guys. So the verdict is in. A lot of you guys don't know this. It's public information. It comes out at 12 o'clock. Due to the fact that it's my case, they released it to the lawyer at 10:30. So I do have the submission from the trial judges at the Ontario Appeals Court. And without further ado, I want to share it with you guys. And I'm asking everybody to, I'm not looking at the chats right now because I want to read this with you in real time. And I'm going to skip a lot of the, you know, the meat and potatoes and the guts of what happened. We all know what happened. But what I am going to ask every single person out there right now is I want you to listen to me right now. Whatever this decision comes out, we use our heads. We use our heads because we are better than them. We use our hearts because our hearts are stronger. And we use our faith because our faith is what got us here. That video that I just shared with everybody out there, I shared on it for a reason. We were talking about this stuff long before we decided to travel down the road. We were talking about this stuff long before the implementation of the draconian measures that the government had forced upon us. And in Alberta, we were strongly against everything, and we were very loud in our province of Alberta. But what we have now is we are up against an elite force. We are up against a liberal government that does not care about us. They only care about an agenda that needs to be pursued for the next 10 years. They are worried about our new world order. They are putting you into a government organization with non-elected officials, and that is their move. But again, I am stressing that whatever this outcome is, that we use our heads, our hearts, and our faith. And I am asking each and every one of you guys to share this out to everybody. I'll tell you right now, I know what the decision is. Without further ado, let's go. Ladies and gentlemen, boys and girls, get your coffees, get your joints, get your beers, get whatever you need. With respect, we are persuaded that at each of these conclusions about the interpretation of Section 423, subsection 1, is incorrect. These errors appear to have arisen from the trial judge's well-intentioned effort to interpret the law to accommodate political protest, but the outcome he achieved cannot be sustained as a matter of law. We begin with the use he made of the fact that the Freedom Convoy was part of a political protest. The Crown argues that the trial judge erred in finding that Mr. King did not act wrongly because he was participating in a lawful protest. We agree that the trial judge erred in this way. There may have been multiple cases of criminal convictions arising from the criminal acts committed during protests, including convictions contrary to Section 423, subsection 1, Section G, Manual Billy R. v. Pascal, 2006. The jealous protection the law provides to the right of political protest applies only so long as the protest is being conducted lawfully. Chazon J.A. put it in R.V. de Felice 2010 BCCA 273255 CCC 3rd. Undertaking illegal activity as part of expressing disagreement and advocating is not lawful. While the dictum comes from a sentence appeal, it has been cited with approval by Canadian appellate courts affirming convictions for mischief and criminal harassment associated with protests. See R.V. Arthur Pulowski. Leave to appeal refused. Criminal harassment relating to an animal rights protest, another one. Indeed, we agree with Slater J.A. when he said in concurring reasons in Pulowski at paragraph 107 that mass obstruction of public highways is not a form of peaceful protest. The fundamental freedoms of expression and assembly do not encompass obstructing public highways or inciting anyone else to do so. Put simply, criminal conduct is not less criminal because it occurs during a lawful protest. We are therefore persuaded that the trial judge erred by concluding that Mr. King did not act wrongfully and without lawful authority because events occurred as part of a political protest. The trial judge similarly erred in treating Section 423(1) of the Criminal Code as requiring proof of threats or violence when highways are obstructed during otherwise lawful demonstrations. He offered a policy explanation for this conclusion, explaining that otherwise Section 423 subsection 1 would capture a broad range of lawful protests against government actions in which there is no proven intent to intimidate individuals. Whatever one may think of the policy choice, this reasoning entails the concern expressed by the trial judge, fails to recognize the point just made that as a matter of law, the right to peaceful protest does not include the right to engage in otherwise criminal conduct in support of protest goals. With respect, by attempting to limit the reach of Section 423 subsection 1 in this way, the trial judge moved beyond interpretation of the provision and engaged in impermissible legislating. See Wilson v. British Columbia, Superintendent of Motor Vehicles. There was no constitutional challenge before him to invite such reasoning, nor is there an ambiguity in the legislation that could invite the use of the charter principles into the interpretation. See R.V. Rogers. The approach the trial judge took was therefore in error, and so, too, was the conclusion he arrived at. There is no basis in the language of the enactment interpreted in its context for finding that an offense charged contrary to Section 423, subsection 1, section G, requires proof of threats or acts of violence. Moreover, including this additional element would contravene the presumption against tautology. Pardon my expression on that one if I've said that wrong. A principle of statutory interpretation that presumes legislatures avoid superfluous words and that every word in a statute makes sense and has a role to play in advancing the legislative purpose. R.V. Gallone. Make this mode of committing intimidation redundant, depriving it of all meaning, since subsection 423(1), subsection A, already prohibits using violence or threats of violence as a means of compelling a person, whether this conduct is done to block or obstruct a highway or otherwise. The only times that proof of acts of violence or threats is a required element of an intimidation offense is if the charge is laid contrary to subsection 423, section 1, subsection A, or Section 423, subsection 1B, the latter of which prohibits threats that violence or other injury will be done. Relatedly, the trial judge erred by finding that the specific intent requirement necessitates proof of intention to intimidate individuals. The requisite specific intention is spelled out in the chapeau to Section 423, subsection 1, and nowhere does it refer to the need for an intention to intimidate. This is no doubt because it was unnecessary for Parliament to include such an element. Each of the modes of commission enumerated in Section 423 involve inherently intimidating conduct, such that the intention to do any of the enumerated acts in subsection 423, section 1, subsection A to 423, section 1, subsection G, inherently includes the intention to intimidate, as Slater J.A. commented in Pavlovsky's at paragraph 107. Blockading a highway is an inherently aggressive and potentially violent form of conduct designed to intimidate and impede the movement of third parties. If the trial judge was influenced in adopting the interpretation, he did by the fact that the offense appears under the heading intimidation in the criminal code. He should not have been. While headings may be relevant in the interpretation of federal legislation, they will never be determinative of legislative intention and cannot operate to change the clear and unambiguous meaning of a particular provision. R.V. Davis, 1999, 3 SCR 759, at paragraphs 53-54. Here, all required elements of the offense of intimidation are spelled out in the text of Section 423, subsection 1, subsection G itself. It is clear and unambiguous that neither a subjective intention to intimidate individuals nor threats or acts of violence are essential elements of Section 423, section 1, subsection G. The trial judge therefore erred in requiring proof of an act of violence or threat and an intention to intimidate. These are not elements that have to be proved to support a conviction contrary to Section 423(1), subsection G. Finally, we agree that the trial judge erred in finding that the government of Canada is not a person and rejecting on the basis the Crown's second theory as to how the specific intent requirement was satisfied. Section 2 of the Criminal Code stipulates that the terms everyone, person, and owner, and similar expressions include Her Majesty. Emphasis added. That's why I said it like that. We need not decide whether the House of Commons and the Senate, the legislative branches of the government of Canada, are captured by the term Her Majesty. But certainly the Crown and right of Canada through the executive is, see Interpretation Act, RSC 1985, Alberta Government Telephones v. Canada, Canadian Radio, Television, blah, blah, blah. Since Mr. King's focus was on government COVID-19 policies at large, including executive initiatives, his conduct was aimed at another person who can be compelled, contrary to Section 423, subsection 1, to abstain from doing anything that he or she has a lawful right to do, or to do anything that he or she has a lawful right to abstain from doing. The trial judge therefore committed layered legal errors in his interpretation of Section 423, Section 1, subsection G. The acquittal ordered on count 6 must be set aside based on the authority in RV Graveline 2006 SCC 16. It is not only certain that the errors described had material bearing on Mr. King's acquittal, but they led directly to that outcome, which cannot stand. Interesting, eh? Evidence that proves that I didn't do anything violent are not allowed to stand. Should a conviction be substituted? Indeed, this is an appropriate case for entering a verdict of guilty, pursuant to section 686 of the Criminal Code, rather than sending this charge back to be retried on a correct application of the law. Mr. King should have been found guilty of count 6. First, the trial judge found that Mr. King personally participated in blocking or obstructing Kent Street, personally led a slow roll that crippled access to the Ottawa airport, that's lie, and encouraged his followers repeatedly to block and obstruct roads. This satisfies the Act's requirement. Second, it is obvious based on the trial judge's factual findings that the blocking and obstruction were done wrongfully and without lawful authority. Blocking roads as a protest tactic was inherently wrong, and there was no pretense made of a lawful right to do so. This was an inherently intimidating act of power undertaken to prevent others entitled to use those roads from using them, as the trial judge found. This conduct was designed to and had the effect of interfering with and obstructing the use and enjoyment of property of downtown residents and workers. Moreover, the trial judge found that Mr. King was guilty of the offense of mischief when participating in and encouraging the gridlock. There can be no doubt on this basis alone that the blocking and obstructing of streets was being conducted wrongfully and without lawful authority, satisfying the condition requirements of the offense. We are therefore of the opinion that the condition requirements is also proved beyond a reasonable doubt on the factual findings the trial judge made. Third, we are persuaded, based on the trial judge's factual findings, that the required specific intent was also present. Those findings leave no reasonable doubt that the tactic that Mr. King employed to compel the government to change its COVID-19 policies was to block and obstruct roads for the purpose of compelling residents to abstain from enjoying their lawful rights to use their area roads and enjoy their lawful property rights, thereby satisfying the Crown's first theory relating to the specific intent requirement. Characterized alternatively, his purpose was to use the pressure that was being exerted against area residents to compel the government of Canada to abstain from exercising its lawful authority to pursue the COVID-19 policies it considered to be in the public interest, and to instead change these policies to satisfy Mr. King. The trial judge's mooted characterization of the intention of those involved in the Freedom Convoy as being to persuade the government to change its policies is not a finding to the contrary. The trial judge fully appreciated that participants were not relying on persuasion alone, but were using pressure tactics. Specifically, the trial judge found that Mr. King intended, along with other Freedom Convoy participants, and we know who those people are, to bring the central core of the city to a standstill, and that his intention was to stay until the government agreed to terminate COVID-19 mandates. It is obvious that he was not relying on political persuasion to accomplish this outcome. Instead, his preferred tactic was the threat that, in the words of the trial judge, downtown residents, as well as owners and employees of small businesses and other institutions, would continue to suffer. Those words never came into my mouth. Significant interferences in the use and enjoyment of their property. Never once. Until Mr. King got what he and the other protesters wanted. The trial judge found in this regard that Mr. King told his followers at the outset that they had put the fear of God in the government, and that the rolling into Ottawa with 1 million fucking trucks, quote, would make the government even more scared. He said in a post that their strategy was working beautiful. When he believed the government was being brought in to negotiate, the trial judge also found that on February 10th, 2022, Mr. King posted, "We haven't left Ottawa and we don't plan on leaving anytime soon until you get those politicians. Get them going, get them talking, get them understanding that, hey, things need to change in Canada and they need to change really fast." Agreed. It can be seen from the foregoing that we do not accept the submissions made by Mr. King's appellate counsel. First, the conduct by Mr. King that satisfied the act requirement of blocking or obstructing a highway was not a constitutionally protected expression. It was an illegal act done wrongfully and without lawful authority. Because blocking or obstructing a road is both civilly actionable conduct and inherently wrongful act, Mr. King's unlawful act of blocking and obstructing highways became criminal in this case because it was undertaken for the purpose of compelling the area residents to abstain from what they had a lawful right to do, and the government of Canada to do what it had the lawful right to abstain from doing. There is no conflation between the wrongful act and the coercive purpose here. They are distinct elements of the offense, all of which are present in the trial judge's findings. We therefore allow the conviction appeal, set aside the acquittal on count 6, and substitute a conviction. Do not go to jail. Do not pass go. Do not collect $200. You will be sent to a sentencing hearing. Because this court has substituted a conviction on the count of intimidation, contrary to Section 423, Section 1, subsection G of the Criminal Code, the matter must be remitted back to the Superior Court of Justice for a new sentencing hearing. While it is for the new sentencing judge to determine a fit and appropriate sentence, we offer the following observations by way of guidance. The trial judge imposed a global sentence consisting of a 12-month conditional sentence of imprisonment, applying 9 months credit for pre-sentence custody and restrictive bail conditions. He sentenced Mr. King to serve the remaining 3 months of the conditional sentence, followed by 1 year of probation and opting for this lenient penalty. The trial judge expressed a concern that too harsh a sentence could chill legitimate political expression, as he put it at paragraph 31 of his sentencing decision. The risk is that an overly severe sentence of imprisonment in the context of legitimate constitutionally protected activity can have the effect of creating a chill or a fear of participation in political expression such as demonstrations or protests. We agree that caution is warranted when sentencing individuals for conduct that could potentially fall within a constitutional zone of protection. However, the conduct in this case far exceeded the bounds of legitimate expression. This was not a peaceful protest that unfortunately grew out of control, was allowed to go on, and morphed into criminal activity. As the trial judge suggested in his sentencing reasons, rather this was from the outset a coordinated, targeted attack on Ottawa residents aimed at coercing change through highly disruptive criminal conduct. As the trial judge observed in his reason for judgment, there was overwhelming evidence that even before the arrival of the Freedom Convoy in Ottawa, Mr. King planned to effect an occupation, gridlock the area, and cause acute distress to residents. Merchants and workers through the continuous honking of horns and other disruptive activities. Mr. King not only incited these activities, he instructed his followers to resist police and ignore court-ordered injunctions. This conduct, properly characterized, was an attack on the rule of law and the democratic principles essential to the maintenance of a just, peaceful, and safe society. We have not had the benefit of complete sentencing submissions and make no comments on what a fit sentence would be. However, a fit sentence must reflect a full appreciation of the public impact of the offenses, as well as the scope, duration, and persistence of Mr. King's actions. Released July 17th, 2026. There you have it. There it is, folks. This is insanity. Insane. This is absolutely insane. So now what we have, ladies and gentlemen, is we have 60 days to file an appeal to the Supreme Court of Canada, of which I've been telling people that they've always wanted this in front of the Supreme Court. This is their goal. At the same time, a sentencing appearance will be made. I will be going up in front of a sentencing judge. We have a lot of factors that play, albeit I have time served of 1 year, plus 1 year probation, plus 2.5 years of extreme bail conditions. That will play in the favor. But it appears that, ladies and gentlemen, I will be going for penitentiary time. Could be 2 years plus a day, or it could be 5 years. So, as everybody knows, this is a absolute horrible finding. As we read further on, I didn't share with many people. They didn't even read or one paragraph comment of all our facts that we put in. Guys, I'm going to tell you this right now. I do not have the money to fight this in Supreme Court. I do not have the funds, period. So I may not take this to the Supreme Court, and I may just take my licks and go to the pen. I'll tell you right now that we did what we did to save people. And unfortunately, our government didn't see it that way. Unfortunately, these judges ruled everything against what Justice Hacklin had ruled. The fact that Justice Hacklin has now since retired makes this even more distressing, because now they get to judge shop. Now they get to judge shop, and what they do is hand select a personal judge that will favor in their manner. To the left, I hope you're doing your happy dances right now. You got what you wanted. Mm-hmm. You got what you wanted. So to all those people who were crying about how we disrupted you, you got it. Congratulations. To the Crown Attorney's Office, I bet you're doing a happy dance right now. And I hope you're happy, because you have just showed the ignorance in the courts of what we all went through. How many people died because of your mandates that were bullshit? How many people lost their businesses? How many divorces? How many foreclosures of people's homes because they couldn't afford to live, because they had one thing and one thing only, and that was the choice of bodily autonomy. My body, my choice. Many people speak up about that. You can protest, you can firebomb abortion clinics, you can do everything else that is violent towards that, because it's your body, your choice. But when it came to this, well, that got thrown out the window. I will go to prison. I am going to the penitentiary. And hopefully the sentencing judge sees that I have served many, months of time. To the others that are pending appeal, I want to thank you for expediting this decision. I know you're waiting for an appeal because the Crown appealed you, and you got your lawyers to contact the Ontario Appellate Court to try and expedite the decision on my appeal so that it could help benefit your appeal. It backfired once again. A rash decision was made here. I am going to serve penitentiary time now. This doesn't work in your favor, and you should have never stuck your nose in my case. Your lawyers should have never stuck your nose in my case. Remember, we weren't co-accused. You wanted your own separate trial. But I have, upon good authority and from my lawyers, I am not making this shit up, that your lawyers pressured for a decision on my case because it pending the outcome of your appeal. It backfired again.
Can I ask a question?
Yeah.
So obviously this is case law again.
Yeah.
And you're the president of that.
Mm-hmm.
Now, because they appealed also.
Yeah.
What's going to be different?
Well, because mine was overturned, the Crown's appeal will be approved on them.
Even though they've appealed?
Even though they've appealed, this now sets precedence in the appeals court. So all that money you're wasting of hard-working people could have just been a team, right? Nah. You needed a sacrificial lamb, right? The ritualistic sacrifice to get you into that political theater, that political realm. I get it. Guys, we all know that Canada is broken. We all know that the judicial system has been weaponized against us. We also know that this Liberal government is moving in lockstep forward in ways we've never seen before. Where's the GoFundMe? This cannot pass. Just so you know, I'll put this up if you guys care to help. This is the Give, Send, Go in the bottom. I'll also copy the link if I can. We need everybody's help on this one. I need to make sure that my fiance is going to be okay while I go away. Not gonna lie, this fucking sucks.
No idea, Craig.
Like I said at the beginning, use your minds, guys. Use your minds. Use your heart. And use your faith. Right now, we're going to have a chat with Brian at 5:30 when he gets off work. We're going to know what our next steps. I'll see. I don't know, man. I don't know. At this point, I don't know. I don't know what's left to do. And I'm not saying what I think on here. But this fucking blows. And do I run? No. So to all those people out there saying run and leave the country, fuck you. I will stand here till I have nothing left in me. I am not running away. I will not abandon my post. I will take my charges. I will take my decisions. I will take my sentence, and I will do it standing on my head. I will do it wearing that badge of honor and proud that I stood up for my country. I will serve my penitentiary time with my head held high. I will serve my penitentiary time right. Maybe learn law. Maybe I get a law degree while I'm in there. Maybe I utilize every asset at my tip of my fingers that they give every other criminal in prison. And we come out of this stronger, and we come out of this smarter, and we come out of this better. Why? Because we are better than them. We are stronger than them. And we scared the bejesus out of them. And this is why the harsh sentence. Hey, man, what's that guy? What's that guy in Africa?
What?
What's that guy? Nelson Mandela went to jail for 20 years because of this. Nelson Mandela sat in prison, and when he got out, he became the president of Africa, I think.
You want to be best friends with Oprah, too?
Want to be best friends with Oprah? Yeah, I could be best friends with Oprah.
That's not a flex.
I can do nothing but laugh at this point. It proves everything to me. It proves that this country is a dumpster fire, and it's going down, down, down. But guys, know this. I've already served some time, so that will be accounted for. That will be time served. As well as you read in the, and I'll read it again to you here. This conduct properly characterized was an attack on it. However, right here, however, a fit sentence must reflect a full appreciation of the public impact of the offenses, as well as the scope, duration, and persistence of Mr. King's actions. So it's up to the sentencing judge at this point. I will be heading back to court at some point, not within the next 60 days. Guys, we have to file this to the Supreme Court. I don't know how that process works. I don't know how.
Somebody just said something in the chat about that.
Where?
I lost it now. Pat, just file the appeal with the Supreme Court yourself. You do not need lawyers to appeal. The filing fees are not that high, he said.
Oh, okay. Okay, thanks, guys. I don't know how this works. I don't know what the next steps are. Yeah. I guess we'll know here in a little bit. That's fine, Elsie. I get that, man. That's not what I was saying. It's not what I'm saying, bud. But hey, thanks for the comment. We're fine.
What was that?
Steve, guy from Edmonton.
What's that on my screen right now? Everything's flashing.
What? Where?
Okay.
All right, guys. So that is the outcome. And I guess we're going to carry on with the rest of our day.
How?
I don't know.
Like, what do you do?
I don't know. Jump on my Harley and go for a ride.
I don't even want to do that. Like, I'm frozen. I don't.
Yeah. Kind of gobstruck myself. At this point, guys, I'm going to be bowing out, pending my sentencing. Probably won't be online for a while. maybe 5 years. Fuck.
That's
one of the good points.
Not true.
What?
No, but I mean, like, you will be online.
One of the good things, though, guys, and I want to say this: I'm not a violent criminal, and I've already gone through this already with Natasha when we were discussing options. I'm not a violent criminal. I don't have a a criminal record, well, other than a mischief now and now an intimidation, which actually this was supposed to go to a trial judge, and that's something I want to express. This was supposed to be brought back for a retrial, but they overstepped the retrial and went right to a conviction. The reason for that is, and now that this has been done, I am going to release videos and do a piece on the law enforcement officer that absolutely lied in testimony, saying they had no interaction and no involvement with me. And in fact, I'll play that video of the officer when we were at the airport saying we were doing nothing wrong. And then she lied on the stand and stated that she had no interaction with me. So I will provide that information. I will look that information up, but that was going to be brought forth in the trial, and it was going to be put out as evidence, but we knew that the intimidation charges were being thrown out, so we didn't pursue any more evidence. But when we showed the judge, or we showed the Crown this evidence, he said, yeah, there's no need for that. So we have evidence that proves that the officers lied on the stand and should be charged for perjury, as well as evidence to prove that there was zero disruptions at the airport, zero disruptions to traffic, zero disruptions to flight schedule, all reported by the CBC as well as the Ottawa International Airport, as well as video evidence of the law enforcement officer asking me while we were in the truck, who was in charge. I said, this is everybody's thing. And I said, why, are we doing anything wrong? She says, no, you guys are doing everything wrong. Everything's all good. So we know that the judicial system is against us. I am looking at 5 years. I will be going back in front of a sentencing judge and being resentenced within the next 60 days. And enjoy your summers, ladies and gentlemen.
Even a blind man can see what we are all seeing, and yet you're trying to gaslight us into pretending like it's just all regular and that we are the bad guys. That is the truth. The truth does hurt, and people want to know who killed Charlie Kirk.
It's like a radiant beacon on a hill, drawing you close and holds you still. Carried by gentle warriors, clothed in God's will. Shadows try to hide the beams, but it shines bright for all who see. Truth can't be put out, silence trampled by violence. It's a roaring flame, proclaims can't be restrained, won't bend a knee, sets the captives free. Right here alive, yeah, you and me. True, yeah, true. Thinking of those who carried the torch in their day, dreaming their dreams, walking their faith. Fearless to sharing Jesus' ways, paving the way. Sacrifice is not forgotten, but your light spreads love, still living